You're listening to Discovery, a podcast presented by the University of Washington School of Law.
Welcome to Discovery, presented by the University of Washington School of Law. I'm your host, John Blumster, and today we're here with a very special guest. We're speaking with Erwin Chemerinsky, Dean of the University of California, Berkeley School of Law. Dean Chemerinsky is a prolific constitutional scholar and Supreme Court advocate who is one of the most influential legal academics and lawyers in the country. He's written a number of best-selling books, including his latest work, We the People, a progressive reading of the Constitution for the 21st century, and he's a leading voice on some of the most important issues of our time. He is here today to discuss the future of the U.S. Supreme Court and what it means for the turning point in American history at which we find ourselves today. So, nice light topic, and we're very excited. So, Erwin, thank you so much for joining us here on
My
Discover.
great pleasure to be with you.
So, before we dive into 2019, I'd really like to take a step back to kind of set the stage. So, since 2016 and the death of Justice Antonin Scalia, the Supreme Court, it feels, has gone through some kind of seismic shift in just a couple years. Is that feeling accurate? And is there some kind of historical precedent that we could draw from on this?
There's no doubt the court has gone through what you call a seismic shift. We replaced Antonin Scalia with somebody just as conservative, Neil Gorsuch, and replaced Anthony Kennedy with somebody even more conservative, Brett Kavanaugh. Now, there are a couple effects of this. One is, no longer is there a swing justice on the court. Since 1969, while Republicans have had a majority of the seats on the Supreme Court, there's always been a swing justice, a Lewis Powell, a Sandra O'Connor, and Anthony Kennedy, who would go along with the liberal justices in some of those high-profile, controversial areas, like abortion, affirmative action, gay and lesbian rights. No longer is there such a swing justice. Now there are 5 solid conservatives on the court. The other effect is that we've replaced older justices with much younger justices. Neil Gorsuch is 51. Brett Kavanaugh is 53. It's likely they're going to be on the court for decades to come.
So Kennedy's retirement raised a lot of questions about the timing. In general, do you think Supreme Court justices are aware of the societal context or the timing of when they choose to serve or not serve? Because there was a lot of criticism around, resigning during the Trump administration.
The justices are tremendously aware of the context of their service and resignation. Sometimes they have no choice about when to leave the court. Sometimes they die in office. Sometimes they choice and time their resignation so they have a president of a similar ideology pick their successor. Sometimes they just choose to retire because it's right for them and their lives at that moment in time.
So after Scalia's death, President Obama appointed Judge Merrick Garland. That nomination was subsequently blocked by Senate Majority Leader Mitch McConnell. Then, after President Trump was elected, they abolished the filibuster so they could confirm Neil Gorsuch with just 51 votes. So, if these kinds of actions were possible, how come nobody used them before?
Prior to 2016, 24 times in American history, there had been a vacancy during the last year of a president's term. In 21 of 24 instances, the Senate confirmed the nominee. In 3 instances, the Senate denied confirmation. Never before had the Senate said, no hearings, no vote. Why wasn't it done before? I think the Constitution assumes a high level of good faith on the part of those who govern us. And I think always before the Senate acted in good faith. Here I think that what the Senate did, keeping the seat open for almost a year, was not at all good faith. In terms of eliminating the filibuster, Democrats eliminated the filibuster for federal district court and court of appeals nominations when President Obama was in office. Republicans eliminated for Supreme Court nominations when President Trump was in office.
Has this established some kind of precedent? If these tools are now known to be readily available to the ruling congressional party, do you think there will be pressure from constituents and other outside forces to use them in the future?
I think so long as the president and the Senate are of the same political party, the president is going to be able to get anyone the president wants through with the rarest of exceptions. I think when the president and the Senate are of different political parties, it's not clear that the president is going to get anyone through, at least until there's a change in our deeply polarized times. I think at the very least, the blocking of Merrick Garland would mean if you had a Republican president, a Democratic Senate, then no one the president would nominate during the last 2 years of office is confirmed. And probably it'll be the same if it's a Democratic president, Republican Senate. I think the interesting question is going to be if the president and the Senate are of different political parties, will the Senate even confirm in the first 2 years of the presidency? One effect of all of this is going to be that you're going to have, I think, much more ideological nominees for the Supreme Court, the Court of Appeals, and the District Court, so long as the president and the Senate are the same political party. Because no longer does the president have to worry about a filibuster. No longer does the president have to worry about placating the minority party. And I think we're already seeing that with Donald Trump, where he's getting nominees for the Federal Court of Appeals confirmed at a record rate. And they are overwhelmingly, ideologically very conservative.
And that brings up a very interesting point. This trend of young conservative justices being elected to the Supreme Court, does that not only reflect a trend of more conservative justices in the lower courts, but also getting younger and, will be serving for a longer period of time?
I don't think that the trend towards younger justices is anything new. Clarence Thomas was 43 years old when he was confirmed in 1991. John Roberts, Elena Kagan reached 50. Neil Gorsuch was 49. So I picked both Republican and Democratic nominees for the Supreme Court. But what we are seeing is very young individuals being put on Federal Court of Appeals, often very ideologically conservative and defined individuals. I'll pick an example. Former student of mine when I taught at Duke, Allison Jones Rushing, was just confirmed for the United States Court of Appeals for the Fourth Circuit. She's 37 years old. She has relatively little legal experience, rarely having argued a case in court or never having first chaired a trial, but she has impeccable conservative credentials. She clerked for Judge Gorsuch on the 10th Circuit, Judge Santella on the D.C. Circuit, Clarence Thomas on the Supreme Court. And I think she's the prototype who President Trump is trying to put on the Federal Court of Appeals. Very young, very conservative individuals.
Getting back to the idea of this swing vote or lack thereof, what effects are we seeing already? Is there a specific case that stands out to you where that swing vote really could have been the difference that now is at the whim of an ideological split?
It's important to remember we're speaking in mid-April of 2019. The court has decided relatively few cases yet. We'll get the decisions down by the end of June. But I think I can point to a couple of examples where it wasn't written opinions, but still rulings by the Supreme Court, where the replacement of Anthony Kennedy with Brett Kavanaugh made all the difference. One concerned President Trump's executive order to ban transgender individuals from serving in the military. President Obama had issued an executive order based on a detailed study by the RAND Corporation to allow transgender individuals to serve. President Obama issued an executive order to the contrary, implemented by a Defense Department directive from March 2019. 3 federal district courts around the country issued preliminary injunctions saying the Trump executive order was likely unconstitutional because it denied equal protection to transgender individuals. The Supreme Court, without waiting for Court of Appeals decisions, on its own lifted the preliminary injunctions. The court doing so 5-4, Roberts, Thomas, Alito, Gorsuch, Kavanaugh in the majority, Ginsburg, Breyer, Sotomayor, and Kagan dissenting. Given Anthony Kennedy's record with regard to lesbian, gay, transgender rights, I think that Kennedy would have come out differently on that. Another example concerns the death penalty. There was a high-profile instance in January of an individual who was going to be put to death, and he was Muslim, and wanted his imam to be with him. And the prison refused to allow it. And the Supreme Court, 5-4, allowed the execution to go forward without his having clergy, even though Christian individuals could have had a minister with them at the time of execution.
One of the things you wrote about early this year was about how these 3 issues that have come before the court in this early going have been the transgender military ban, gun control, and free speech as it relates to the exercise of religious freedom. Why do you home in on these issues, and what do they show in terms of the trend that the court is heading?
I think there are several areas where the replacement of Kennedy with Kavanaugh is going to make all the difference in terms of people's rights. And the ones that you mention are examples of these. Others that I'd point to, I think abortion rights, affirmative action, touched on gay and lesbian rights, punishment in criminal cases. These are places where Kennedy often would side with the liberals, and there's no reason to believe Kavanaugh will do so. And the early indications are Kavanaugh won't do so, which means the change in constitutional law.
In the immediate future for 2019, what do you see as one of the most consequential cases that may come before the Supreme Court this year?
I think that I'll point to two areas that are on the docket of the Supreme Court this term. One of them concerns partisan gerrymandering. Partisan gerrymandering was where the political party that controls the legislature draws election districts to maximize, say, seats for that party. It's nothing new. It takes its name from Elbridge Gerry, a governor of Massachusetts early in American history. But what's changed is sophisticated computer programs make it possible to engage in partisan gerrymandering far more precision than ever before. There are two cases on the docket this term, Rucho versus Common Cause and Limon versus Benesek, that involve whether federal courts can continue to hear challenges to partisan gerrymandering, and if so, when partisan gerrymandering violates the Constitution. The other case involves the census. It's Department of Commerce versus New York. The Department of Commerce is responsible for administering the census. There is obviously to be a census in 2020. Department of Commerce decided to include a question on the census about whether a person is a citizen. No such question has been asked since 1960. The concern has always been that it'll cause some people to not fill out the census forms. Federal district courts have found that this is so arbitrary and irrational as to violate the Federal Administrative Procedures Act. They've also said it's unconstitutional. The Constitution requires there be an accurate enumeration of all persons. The federal district courts have said asking about citizenship will mean we'll never get that accurate count. The Supreme Court will be hearing that case very soon.
There have been a number of proposals recently on ways to reform the court, including term limits, expanding the court to 15 justices, giving Republicans and Democrats equal numbers of appointees. Do any of these ideas actually have traction? And in your opinion, are any of those feasible?
Let me take them one at a time because they're all quite different. In terms of expanding the number of, let me start with term limits for justices, your first example. I think that term limits would be a great idea. I would favor 18-year non-renewable terms. In part, that's because life expectancy, thankfully, is a lot longer today than it was in 1787. Clarence Thomas, I mentioned, was 53 years old when he was put on the court. Elena Kagan and John Roberts were 50. If they serve until they're 90 years old, the age with Justice John Paul Stevens retired, they'll be on the court 47, 40 years. That's too much power in a single person's hands for too long a period of time. Also, too much now depends on the accident of history. Richard Nixon had 4 vacancies to fill in his first 2 years in office. Donald Trump has had 2 to fill in his first 2 years in office. But Jimmy Carter had no vacancies to fill in his 4 years as president. 18-year non-renewal terms mean a vacancy every 2 years. All presidents would have about the same influence. But I think that would take a constitutional amendment, and that's highly unlikely. You mentioned increasing the size of the Supreme Court. The size of the Supreme Court is set by statute, not the Constitution. Congress could increase the size of the Supreme Court. And I expect that if the Democrats were to win the presidency in both houses of Congress in 2020, they would consider this. But we've had 9 justices since 1868. Past attempts to increase the size of the court so as to change its decisions have been rebuked. President Roosevelt proposed this in 1936, and it was rejected. And so I think it would be very controversial if the Democrats were to try to do this.
So ultimately, and you write about this extensively in your book, The Case Against the Supreme Court is supposed to be that third branch of government, that impartial referee that protects our society from the whims of the party in power. Do you believe that the court as constructed, given the trends that we've seen both in our society and our politics, Do you think that ultimately this court will be able to live up to that foundational charge?
I believe the Supreme Court has often failed throughout American history, often at the most important times. I think of the Supreme Court's dismal history with regard to race. I think of it upholding the evacuation of Japanese Americans on the West Coast during World War II. I think more recently of its decisions in campaign finance, like Citizens United. I have great doubts about the current court and whether it will advance liberty and equality. But I also don't know of an alternative that's better than having a court with this responsibility. I just have hope in the long term we'll go back to a court that will, as we've seen throughout the course of American history, mean greater freedom and greater equality.
And in the short term, what can we do as Americans? What can young lawyers and scholars do to be a part of that change and to really find that balance for the benefit of all Americans?
I think we're going to need to look elsewhere than the Supreme Court, at least for the years to come. So I think increasingly we're going to need to turn to state constitutions and state courts to advance liberty and equality. I think we need to turn to the political process more. And we need to remember elections really matter. If Merrick Garland were on the court instead of Neil Gorsuch, so many of the things we've talked about and so many other things would have simply come out differently.
Where do you see a spark of hope for the future? What is encouraging you right now as we kind of look ahead?
History. If you look at the course of American history, there's been tremendous advances with regard to equality and freedom. Though we have an enormous way to go if you focus on race or sex or sexual orientation, we've still made a great deal of progress. And I think of sexual orientation. As recently as 2003, there was no state in the country that allowed gays and lesbians to marry. Within 12 years, every state in the country had to allow gays and lesbians to marry. That's enormous progress. I think Dr. Martin Luther King got it right when he said that the arc of the moral universe is long and it bends towards justice.
Erwin Chemerinsky is Dean of the University of California, Berkeley School of Law. You can read more of his work regularly, among many other places, in the American Bar Association Journal, and you can take a deeper dive in some of his best-selling books, which include Free Speech on Campus, The Case Against the Supreme Court, and his latest, We the People, a progressive reading of the Constitution for the 21st century. Erwin, it's been an honor. Thank you so much for taking the time to join us here.
My great pleasure. Thank you for having me.
Discovery is hosted by John Blumster and produced by Greg Olson. Additional voiceover work by Ben Gonio, with original music by John Blumster. Discovery is recorded in William H. Gates Hall at the University of Washington School of Law in Seattle, with the support of Mario L. Barnes, the Tony Rempe Dean. For more, visit law.uw.edu.